at the beginning of the closing arguments. BNC's chief legal analyst Laura McNeal joins us now. Laura, I know that you have been watching this closely because we've been texting back and forth. But there were two things that she said to me that seemed very compelling. One is, it's like the Super Bowl. Everybody gets a ring, or in this case, all three defendants are equally guilty. And the other was when she said you can't rob something on one day and come back a year later and claim self-defense.
No, I thought she did a phenomenal job. Del, I'm so excited because honestly, I have not seen a closing argument this compelling since Johnny Cochran's closing argument. So this was just phenomenal. And what was so great about it is she said to the jury, use your common sense. Your common sense will tell you this is a crime of assumptions, of racial assumptions. She finally acknowledged the elephant in the room, that the reason they responded the way they did, the McMichaels and Bryant, that day is because Ahmaud Arbery was a black man jogging in a predominantly white neighborhood. Also attacking the credibility of the defense's witnesses. She was right. They were Team McMichaels, and to be bold enough to high five one of the defendants as you were walking out the courtroom, or to motion that motion. Also, she did a wonderful job establishing the obvious. Ahmaud Arbery was defenseless. He had no guns. He at no point in time did he make a threat. All he tried to do was run away. And when she established that, she completely demolished the self-defense that the defense is going to try to put forth to justify February 23rd, 2020, as well as that they were putting forth or instituting a lawful citizen's arrest. She could not have done any better.
Laura, I think that you're not the only one, by the way, that drew the conclusion that this is going to be tough for the defense. Over the weekend, the Arbery family attorney, Lee Merritt, talked about how desperate the lawyers for the defense must be. Take a listen to what he said.
Third parties are influencing this case. They've been doing it from the gallery in this courtroom. They've been doing it outside. This is what a public lynching looks like in the 21st century, with all due respect. Just because they haven't put a gallery up, they haven't put a podium up outside with a hangman's noose on it, doesn't mean that this isn't a trial, despite the best efforts of this court. This isn't a trial that's been infected by mob violence of a woke left mob.
So, of course, that was not Lee Merritt. That was Kevin Goff, the attorney for Roddy Bryant. But he basically is pointing out what the defense attorneys were saying, which is that when you are attacking the crowd outside the courtroom, it could be arguably argued that you don't have much of a case inside the courtroom. Is that correct?
It is, absolutely. This is an act of desperation that you're seeing, and you couldn't have seen it more or captured it more when the camera during the closing arguments panned onto the face of Travis McMichaels. All you could see out of that face was defeat. He knows that he is, as we say, going down. He knows that his defense is not going anywhere. This case is a losing case, and like I said, I cannot wait to see the defense, because I want to see, how do you come back from this strong of a compelling closing argument? What can they possibly say, especially when the prosecution used the defense's own words? Greg McMichaels, Travis McMichaels, he was trapped like a rat. No, at no point in time did he threaten us. Use their own words against them. This is a done deal. They need to be begging for a plea deal before that verdict comes out.
Candace Kelly has been chomping at the bit to get in on this discussion too. She joins us now. Candace, that was exactly my thought, which is right now, if I'm an attorney for the defense, I am walking up to the prosecution and saying, give me anything but life or death. Am I correct?
You are correct. I mean, the bottom line is that if you have the facts on your side, you argue them. If you have the law on your side, you argue it. But if you don't have anything at all, like you said with the clip that we just saw with the attorney Kevin Goff, you just pound your fists on the table, and that's what he's been doing essentially by bringing all these motions that continue to be defeated by the judge. He really had nowhere to turn, and then he ultimately turned to a plea deal, which, as we know, was rejected by the prosecution. So he knows, and the other attorneys know, for the other defendants know, that when they get up there, they need to do a very good job in order to try to win this jury, because this prosecutor, she really laid things out for them to see. And one thing that I really liked that she did was she empowered them before they went behind the scenes, letting them know, you are going to get your own copies of jury instructions. You are Glenn County. You are the ones making the decision. You are the reasonable person in this case. You are in charge. And I think that was very empowering, especially when sometimes these jury instructions are so complicated, as we saw in the Rittenhouse case, where one juror asked to take that information home. I think she empowered them to do their job, and invited them to ask questions if they came to a standstill. And I think that was really important just to move this case along, especially during the week of Thanksgiving, Dal.
Candace, it also seemed to me that whether we as African Americans like it or not, she spoke their language, in the sense that for Black Americans, as I pointed out to Dre, this has always been about jogging while black. Race has not been injected into this trial, despite the objections of many of us in the media who thought that it should be. But I heard her say something that almost signaled to them, you know what they're going to say. That was almost like saying, you know that this is how it works down here, but that's not the law.
Exactly. You know what they're going to say, because you're from here and you understand what it means to be white in America. Most of you are white, but let me tell you something different, and I'm going to do that right now. I also thought that it was interesting that she, used an example of cameras at Walmart. She definitely knows her audience, that these are people who probably go to Walmart quite a bit. And so she was speaking to them, and as you said, the language that they knew in order to drive her points home. She also was just very, very clear, very instructional, like a professor, just breaking things down, giving them examples that they would understand, once again, to empower them when they would go behind doors for their deliberations. But there was this implied race that was also on trial, and as you said, we didn't hear it until the closing arguments, but that's because it was implied. But I think that if it was something that really became at the center, I don't think that those 11 white jurors especially would have known what to do with that, because quite frankly, they're not the ones who experience most of the racism down south. You would have had that one Black juror actually representing for all of African Americans down in Georgia. So I would say that the fact that race stayed out of it might have not muddied the waters, and it's a weird way to look at it, but she was able to get right to the law, right to the facts, without a lot of emotion, and I think that that was a good way to go here for the prosecutor.
Laura, another analogy she used was the bully analogy. She said 3 people following a young man down the hall, and then he finally can't take it anymore and strikes back, but the bullies say, I didn't start it, he started it. I thought she was very effective with that argument, and also the argument saying you can't go to rob the convenience store and then when the guy fights you for the gun, say it was self-defense.
Yeah, she did a wonderful job. It honestly reminded me of my law school days. She sounded like a criminal law professor, the way she broke down those very complicated charges for a jury member and made it very simple and said, this is the analogy. It's the same thing as a 3-on-1. These are 3 bullies that are trying to corner someone. And if, let's just say hypothetically, if Arbery was fighting back, you can't say self-defense when you were the one that started it. You were the one that created the provocation. And so I thought she did a wonderful job in explaining that, because it's very important in dispelling that self-defense claim that the McMichaels and Bryant are trying to put. As they often say, she understood the assignment. And the way she broke this down for the jury members, I think is really going to bode them well, even going as far as to say, you know what, it's just a suggestion, but I suggest that you start from the bottom up. Start with the lowest charges and work your way up methodically. So helping them understand, because you have to keep in mind, a lot of times for jurors, they don't have any legal training. These jury instructions can be very intimidating. But the way that she broke it down, I think they are ready, they accept the charge, and I know they're ready to get in that jury deliberation room as soon as possible.
Okay, now the tough question. I'll begin with you, Candace. Black Americans didn't believe that you could take an AR-15 to a protest and shoot 2 people, killing 2 of them, shoot 3 people, killing 2 of them, and then walk away and be celebrated as a hero on Fox News. But we found out differently in the Rittenhouse case. Are we looking at the possibility of another Rittenhouse in the sense that Black America won't understand the verdict regardless of what the verdict is?
You know what? Listen, Rittenhouse and this particular case, they have a lot of similarities, but Del, there are also a lot of differences. I mean, there were points in that tape, if we all want to be really honest with ourselves and look at it, where Kyle Rittenhouse was attacked, as well as there was a gun that was pointed at him. Now, does this justify the situation overall? Is it morally right? Do we say yes, that it was okay for him to cross state lines and do that? No. But according to the law, those are different facts that are involved. The same thread, but different facts in terms of that will probably get us a different situation or outcome here. In the Arbery case, here we have someone who was running down the street, didn't have anything in terms of attacking anybody. There was no threat, even though they said there was a threat at the last minute in a last-ditch effort through the mouth of Travis McMichael, but there was no threat. They didn't talk about that at the beginning. So here we're talking about something that is completely different, and I am writing on the law and saying that the outcome is going to be completely different than the Rittenhouse case also.
So, Laura, when we talked about it last week, we used the grandma argument. Grandma said, boy, if you'd have kept your butt home, you wouldn't be in trouble and 2 people would still be alive. But in this case, we found out that that's not the way the law works in Wisconsin. Is there going to be another Rittenhouse verdict in the Ahmaud Arbery case?
No, I completely agree with Candace. I think this case is going to have a very different outcome. I think there's definitely going to be a guilty verdict. But the reason there's still that overwhelming doubt within communities of color is because history has a tendency to repeat itself. And what we've seen time and time again is that obviously there's typically not justice when there is a black victim, as we see in this case. And so that's why, despite of what the law says, we know that our criminal justice system unfortunately is riddled with racial bias, and that racial bias influences jury members. And remember, here we have 11 white jurors and 1 black. It also influences judges, prosecutors. We saw how long it took for them to bring charges when this was an obvious crime that had been committed against Ahmaud Arbery. And so that's why there's the reluctance, and hopefully they'll see that justice will be served this time.